famous adage goes that when an elephant in a village dies, then the story of that time is about the elephant. Yes, the elephant in the room the last couple of months in the country has been Bill 7. And finally last week, President Hakainde Hichilema entered the bill into law and becomes part of the Constitution of Zambia Amendment Act number 13 of 2025, bringing to an end one of the most debated constitutional reform processes in recent years. The President has since urged Zambians to put the debate behind them and focus on national unity and development. The Act was unanimously passed by the National Assembly after securing the constitutionally required 2/3 majority and was assented to during a ceremony held at Mulungushi's International Conference Center in Lusaka last week. Among its key provisions, the Act revises the composition of the National Assembly by increasing constituency-based seats from 156 to 226, in line with the Electoral Commission of Zambia's Delimitation report. It also introduces a mixed-member proportional representation system aimed at enhancing representation for women, youth and persons with disabilities. Tonight, on Costa's cross-examination, we summon and examine these provisions and interrogate their implications for Zambia's democracy and governance. My guest is expert in governance and executive director for Zambia's Civil Liberties Union, Isaac Mwanza. Join me shortly, right after this. Good evening. Thank you so much for joining us on Costa's Cross-Examination live on DSTV channel 271. It's 20 on Go TV. Remember that we're streaming live on our Facebook page. It's Diamond TV Online, as well as Diamond Media Zambia. Costa Cross-Examination is now in session. Isaac Mwanza, good evening. You've been summoned to cross-examination.
Thank you very much, Costa. I'm very grateful to be on this cross-examination seat.
Thank you so much. Of course, tonight you join us as Executive Director of Zambia's Civil Liberties Union and a person who's been involved in governance, I should think, for the last 2 decades. You were part of the recent technical committee that went around to collect views, and the last 2 months has seen widespread debate on whether this process was inclusive or not. I know this committee is not what you're representing today, but just give us your experience in terms of your terms of reference and the impact or the lens at which this committee went in terms of collecting views from Zambians in this process.
Yeah, so thank you very much, Costa, once more for hosting me on this cross-examination. As a technical committee, first it was a privilege, and I want to thank President Hichilema for considering me for appointment to the technical committee. Now, as a technical committee, we had our terms of reference. And what people ought to have understood then, which some of them didn't, is that our terms of reference were very broad. They were broad and also specific. Broad in the sense that we needed to look at the electoral process and the electoral system as a whole. We also needed to look at specific items that the government wanted us to inquire to get the views from the public and to also conduct wide consultation with the Zambian people. Mm-hmm. So because the terms of reference were broad, you would see that even our report, what we reported back to government was very broad. It included issues such as appointment of ministers from outside Parliament, which is not part of Bill 10. Bill 10 was
Bill 7, rather.
Bill 7. It was not part of Bill 7. Bill 7 was very specific, whilst our terms of reference were a bit broad. And the way we conducted our consultation was in such a manner that the committee had to go around all the 10 provinces of Zambia. we had to engage people from the districts using the modern technologies. You know, you people in the media, you have these modern technologies where you can talk to your people in the Eastern Province without physically meeting with them. So we employed that technology to ensure that we can get submissions from the people. And true to what we had anticipated, a lot of people turned up to submit their views. We had 11,860 submissions from the people. And this number, Costa, is one of the highest, too, of the submissions that Zambia has ever gotten on constitutional amendment process. The Mungomba Technical Committee had over 12,000, but less than 13,000. Our technical committee had 11,860.
How are you managing to interact with these people? We've heard, allegations that this was a window dressing. It was an orchestrated process where when you went into a province, people were being bussed to lodges or locations where you were, or people had literally been lined up and been given what to submit. And that part of your terms of reference really were to just rubber stamp what was previously put on the floor of Parliament by the Minister in form of Bill 7.
So in our democracy, Costa, you expect that each political party is going to have interest. So if you as a political party you decide to bring your members to submit to the technical committee, the technical committee has no control over who comes to submit. We were receiving submissions from all Zambians. And when I was seated there with my colleagues, we were able to see Zambians. We were not able to see people wearing party regalia to say these are UPND, these are PF. I never saw at any incident when we had those meetings. For instance, I was in Mongu and Choma, Western Province and Southern Province. There was none who came in party regalia to say, I'm UPND, I've come to submit. But you could hear that people are submitting on the same issues, such that even if we carried this process for 2 years, 3 years, 4 years, people are going to be submitting on the same issues.
What were the most common issues?
So the most common issues is that people are asking for delimitation of the constituencies. They were asking that there should be no by-elections, okay? And the technical committee had to evaluate those provisions to say whether we should not have by-elections anymore, because they were saying it is very costly. They were also asking for women representation in Parliament, youth representation in Parliament. The persons with disabilities came out in numbers to submit to say they need to be represented. They want to speak about their welfare. So we heard on these diverse issues. We also heard on issues such as things that are not in Bill, that were not in Bill 7. If a member of Parliament files in a nomination petition, a candidate files in a petition, and the court rules or a tribunal rules that is not qualified, should they have the right to appeal or not? So people submitted to say people must appeal, it is a right. They talked about how long petitions take when they appeal to the Constitutional Court. The High Court, you would hear a petition, a parliamentary petition within 90 days. But when it goes to the Constitutional Court, it sometimes takes 4 years for that petition to be heard. People say, no. We don't need petitions to be heard 4 years. So most of these were the common positions that the Zambians were submitting on our electoral
Again,
process.
I'll ask, this technical committee that you participated or served on was created following the Supreme Court, the Constitution Court ruling, in the Celestine Mukandila and Munia Zulu, case. And again, there's been arguments that whether it should have been 25 members, it should have been independent, it should have had experts. Those were the directives or the pronouncements of the court. In your terms of references, I'll ask again, were you told on what you should stick to in terms of the initial 13, proposed amendments of Bill 7, or in the report which you say tonight was broad, did you put in things in there that you heard from the people that were not part of the initial 13 amendments?
So again, I would want to repeat that we had a broad mandate of looking at the electoral system and the electoral process as a whole. That was a broad mandate. Then you had a specific mandate on looking at some of the issues that are related. For instance, they were related to Bill 7, but they were not framed in the manner that Bill 7 had those provisions. For instance, it would just tell you to say, consult on the tenure of members of parliament. And people were coming to submit to say, we want 2 terms for members of parliament. Others would say members of parliament must remain in parliament until the last day. So you can see the relationship that goes with Bill 7. When you talk about Bill 7 had a provision that said the members of parliament must remain in office until a day before an election. So people would submit on that. But others would submit to say, we want 2 terms for members of parliament. That was not in Bill 7. People would submit on the term of the office of the minister. They were not just talking about whether a minister must vacate office, but they went further to discuss that they want ministers to be appointed outside parliament. And we made that recommendation to say ministers ought to be appointed from outside parliament. So there were various submissions that were made, some which overlapped with Bill 7, and others which were very broad, because that was our mandate.
As a governance expert, one of the key issues in that ruling, in the case I've referred to, was that the court said the process must be conducted in the spirit of the Constitution. And when legal experts interpret this, I think the argument has been that it is not a technical committee or the terms of reference that should give the people the framework of what to submit on, but when it says we the people give unto ourselves this Constitution, was this committee allowing the Zambians that you talk about to come up with any issue that they see fit in the Constitution that represents them, other than those things within the terms of reference?
Yeah, so before I even go to that question, Costa, I need to correct this impression. The technical committee was formed because the civil society organizations, the church, and others who met the president on the 24th of June had argued to say that there was less consultation with the Zambian people, and that there were certain provisions that were very dangerous to our democracy in the Constitution. And an agreement was reached with the president to say this bill must be deferred to allow for a technical committee to be formed so that we can consult on these issues. And we are given latitude by the president to say, can you submit the names of organizations that should come and form part of the technical committee? And the names of the organization, Costa, you might want to know that first there were 2 consortium of civil society organizations, one led by the Civil Society for Poverty Reduction, where Madam Isabel Kelebai was the leader of that consortium during the State House meeting. And it comprised of LAZI, it comprised of NGOCC, and many others. Then you had a consortium of 11 civil society led by myself at that meeting. So we had agreed to say the 2 consortium are going to come up with a list of 14 names, organizations that should be where members of the committee were supposed to be appointed from. So this organization submitted a list of 7, which included Law Association of Zambia, CSPR, and the rest. We submitted 7. The president picked from this consortium, was led by Madam Isabel Mkelebai. Our consortium was led by myself, so he picked differently. And then he also had to pick from other organizations, church mother bodies and all those, their members, so that it can be consultative. So now, I think that the question should be, did the Zambian people turn up to submit? The Zambian people turned up to submit en masse. And they submitted on issues that were not just in Bill 7. In Western Province, they submitted on the issue of the Barose the Barose Agreement. And we included that in our report to say there is an issue of the Barose Agreement which must be resolved. They submitted on ministers outside Parliament. They submitted on the proportional representation in the councils. That was not in Bill 7. Bill 7 was about proportional representation in the councils. So you can see that most of the views that we got were diverse and just not restricted to what government had put in the bill. We didn't even have the clauses to say, consult on clause number 58, article number 61, 62. No. We had terms of reference that were broad and people were submitting on those issues.
You submitted a 176 or 74-page report, if I'm not mistaken.
Yes.
Thereafter, you presented to the President of the Republic, and then that report was subjected to a select committee of Parliament. We now have, finally, Constitution of Zambia Amendment Act number 13 of 2025, which I believe you've taken a look at. Do you feel that this amended act and what was assented to by the President reflects the will of the submissions made to the technical committee?
What I would say, Costa, is that the Act number 13 reflects what government had proposed and also what the people submitted to the technical committee. Our committee report and the recommendations influenced the final outcome of Bill 7. Let me give you an example. An example is the government had proposed that we need 55 new seats in Parliament through delimitation. The technical committee, in its wisdom and after consulting the majority of the Zambian people, these Zambian people said we want delimitation everywhere. We recommended for an increase of 70 new seats. And there was a rationale for increasing by 70 new seats. Maybe we'll discuss that later. But the issue is that the Act number 13 now reflects what the technical committee had proposed in terms of the number of new constituencies. The new constituencies have been increased to 226, which was a proposal by the committee after hearing the people's submissions. The other issue is about the 40 members of parliament who will come on the proportional representation system. Government initial submission was about less than 20, 25. Okay? We propose that it must be 40. That should be the number that is more reasonable, that gives women, more youths, and also increase the number for persons with disabilities. So you have 40 now, even if it has been disaggregated differently, but that number came from the technical committee. What else came into this constitution from the technical committee? It is about by-elections. The technical committee said, no, despite the people, the majority of the people submitting consistently that they don't run by-elections, the technical committee had to look at certain factors in the constitution. If we ended by-elections, would it promote democracy? And part of our terms of reference, our values that were guiding us, was Article 8, which talked about democracy and governance. We needed to make proposals that would enhance democracy and governance. And we said, no, by-elections must remain. And that influenced the outcome that now by-elections will continue. That is what we recommended.
Let's I think, now move into the meat of this, Act number 13 of 2025, because debating the process is water under the bridge now. Yes. Debating the work of the committee is water under the bridge. This is now law. You've spoken about composition of parliament and delimitation. Article 58 of the Constitution is amended by the deletion of Clause 2 and the substitution, therefore, of the following. The number of constituencies shall be equal to the number of the number of constituencies shall be equal to the number of constituency-based seats in the National Assembly as specified in Article 68A. 5. The Constitution is amended by the repeal of Article 68 and the substitution, therefore, of the following. 68, Clause 1, subject to Article 82.5, the National Assembly shall now consist of A, 226 members of Parliament holding constituency-based seats, 40 members of Parliament holding seats under the proportional representation electoral system in accordance with Article 47.2b as follows. 20 women, 15 youth, and 5 persons with disabilities. C, not more than 11 nominated members of Parliament. D, the Vice President. E, the Speaker. And F, the first and second Deputy Speakers. Allow me to start with delimitation. The Act increases constituency-based seats now from 156 to 226. That is by 70 seats, which is what you're saying you proposed as a technical committee. The arguments now are here as follows. There is still uncertainty in terms of what report guided you, or did you base this on? Because ECZ presented before the Select Committee and said they used the 2019 report and a revised 2025 report. There's still uncertainty on which these constituencies are, and how can we enact delimitation when we do not know these constituencies?
Yes, so you may wish to know, and the public may wish to know, Costa, that we had called the Electoral Commission of Zambia to appear before the technical committee. And they gave us a reasoning of why they had recommended 55 new seats. They did not give us the actual data as to where these constituencies are going to be. We are given the privilege of understanding that in 2019 there was delimitation that took place. And the recommendation of the delimitation report in 2019 was that there should be 94 new seats that were supposed to be created.
That was based on the 2019 report. 94 new seats. 94
new seats. Now, when you look at the spread of these 94 seats, I'll read them out, Costa, for the benefit of the public. There was a recommendation that the Central Province, for instance, would have 10 new seats. Copperbelt Province was going to have 12 new seats. Now, when you total all these numbers,
that's from the 2019 report. And what ECZ submitted to you?
This is the benefit we had to understand to say there were 94 new seats. This report was with the executive, and I think it's in public domain. It's circulating in public domain now. Now, the minimum number of seats that were recommended for each province, a minimum across the country, is 7. Okay, so there were seats that were supposed provinces that were supposed to have 7, and there were 3 provinces that were supposed to have 7, including Western Province.
So, like you said earlier, what then logic and rationale did you use? Because the Constitution is very clear in Article 58 that when we are doing delimitation, we should consider population size, geography, and a number of factors. And I think the delimitation issue has been misunderstood to simply mean we're cutting a constituency in half if it is too big. So others have argued on the basis of size. Others have argued on the basis of population. And I've heard examples of Kanyama, for example, may be smaller in size than Kanchibia, but has got more people. And certainly, so what wisdom has been used for you to reduce from 94 to 70? So
if we did delimitation now, probably this number 94, which was in 2019, would have increased to 250 or somewhere there because of the period of time. If you look at the population increase between 2019 and 2025, you might find that the population has increased and you might need to do further delimitation. Already ECZ has told us they registered new voters and others have not yet registered. So if delimitation was going to take place, the number was going to be higher. So our basis of coming up with the 70 was based first on the minimum, which was provided by the 2019 delimitation report, which was 7. So if you created 7 seats in every province,
that is 7 new seats times 10.
Times 10
provinces. That's how you arrived at the 70.
That you arrive at 70. Means that you have a fair distribution of parliamentary seats. Who
then chooses these constituencies?
So now, this is where ECZ has a duty, because when you read that article, which talks about delimitation, ECZ is supposed to publish, and it must consult the stakeholders. So we expect that between now and probably February or so, there must be consultation between ECZ and the stakeholders so that we can know which new seats have been created. But for ourselves, we are not concerned about which one has to be delimited. We looked at what is the minimum.
And I was going to come to the fact that I need you now to wear the civil liberties hat or as a governance expert, away from the technical committee. I think going forward, this is now law.
Yes.
The law provides that going into an election of August next year, after August 13, we should have 226 elected seats.
Exactly.
This change in the law mandates the ECZ then definitely to conduct delimitation and give us 70 new seats. Some of the questions now. The ECZ calendar was already launched and released. It did not, cater for delimitation. We are already in an IMF debt restructuring program. So we're in a very tight fiscal space budget-wise. How do you see this country looking at this? We've already done voter registration. So if I find myself caught up in a constituency which is then delimitated, what happens?
So in 2019, when delimitation was supposed to take place, Costa, the economic dynamics in this country is that Zambia was so much indebted. There was so much debt in 2019, if you remember very well. And our reserves had depleted. I want to understand the economic question from that point of view. And now we are being told by government to say that our reserves have increased. We are a little better, in a much more better position than we were in 2019. So in 2019, if the PF had gone ahead, the PF administration had gone ahead to implement the 94 seats as recommended by ECZ, probably would have been more stressed than we can be now.
Do we have the money now to include 70 seats?
I would not speak on behalf of government, but what I've heard, for instance, what you and me have heard, is that our reserves have increased, that we are much better in terms of the physical stability than we were then.
But you and I,
so where the money
you
will
and
come
I
from,
know that the purpose of reserves is not meant to increase parliamentary seats.
Exactly. But then the question is, that is a good question for the administration, because if in 2019 you as a government you propose 94, ECZ comes up and they still propose 55. We look at the report and the arguments from the people to say these seats where they want to create, for instance, we needed to have a justification. We don't want to go to the public and say, we just proposed 70 from nowhere. We could have proposed the 5 in each province.
I think you've ably answered the logic behind that. My question then is, how feasible do you see this happening 6 months before an election? And I think, for me, the clarity that, I know you're not from the ECZ, but you've participated in this electoral process, is, as a hypothetical question, if I have registered in Lusaka Central, and then Lusaka Central is delimitated into, say, Lusaka South and Lusaka North, do we go back to voter re-registration? It's things like that. What do you foresee happening?
Yeah, so that's a very good question. And I think that it is possible, but also it is very challenging. I must say it is very challenging, because you as a voter, you only know to say you'll be voting from Lusaka Central. You will not know that now you'll be voting from another constituency within Lusaka Central. But I believe that you still go to the same polling station where you are assigned, except that the name of the MP in that area might be different. But you are not moved from that polling station to another polling station to say, now you are going to be voting from this polling station. People still vote from the polling stations where they're registered, except that the division should be done and should be publicized. So ECZ has a bigger task, and I can agree that this will be very challenging for the Electoral Commission of Zambia. For me, this is the time for the Electoral Commission of Zambia to call stakeholders on the table and say, we have been given 70 seats as recommended by the technical committee. And the technical committee rationale was that there should be 7 in each province, as per the 2019 delimitation report. Now, this is how we want to do the delimitation. They will not go back again to conduct something that was already done, and you already have the report of the 2019, which you can use. But it is a question of being transparent. The process must be transparent, because you remember, Costa, that when delimitation takes place, the seats have been publicized. You need to publicize the report in full to say, this is our report of why we have come up with these seats. And that report can be challenged before the Constitutional Court. That is what Article 58 speaks to say when the delimitation takes place, you can go to the court, Constitutional Court, and challenge it. So, for instance, if in Lusaka you created 2 more new seats, the technical committee said 57, you must create 7 seats. But you have created 11 seats in the Eastern Province. People can challenge it and say, why did you create more seats in Eastern Province and Lusaka? And the Constitutional Court is going to hear that challenge. I am not sure how they are going to do it. They might use the principle of equity against our reasoning, where you are saying 777.
So there's a possibility that they may go against what you, because yours is merely a recommendation.
It's a recommendation. They may use the principle of equity to look at where are the largest numbers.
But the law for now mandates that they should be 70. And here then comes the suspicion that probably those with the party in power may want to delimitate in so-called strongholds.
So, we have given Zambians a tool they can use to go to the table with government to say, you want to do delimitation. This was the recommendation. Can we agree on the dynamics? So that when they sit on the table, this is not time for the opposition political party, civil society to begin to say there is this suspicion. The issue now is there's a report by the technical committee, and it has made its rationale of delimitation. Sit on the round table with government and agree to say where are these constituencies going to be. That is where we are now.
Part of this argument to delimitate, and guide me if these were the true submissions of the people that came to submit, is the rationale of delimitation as suggested, an emphasized output that there would be more decentralization and more development on the ground. And here's my argument. The job of a member of parliament is literally to enact laws. They are not implementers per se. Others can argue now that they're sitting in the council. But increasing the number of lawmakers, is that equal to increased or efficient development? And I want to attach this to CDF. In the 2026 budget that Minister Msokotwane delivered at the end of September, it is a budget for 156 constituencies. Now we need to look for 70 times 40 million kwacha in a tight fiscal space. You need to probably increase the physical nature of Parliament as a building itself, because 226 will not fit in its current structure. You need to build more constituency offices, put staff in there. You need to buy more land cruisers to monitor these CDF projects. What's really the feasibility of delivering development in such an environment?
So you and me, Costa, are legal scholars, and I want to agree with you. I don't want to massage this issue. I want to agree with you that some of the reasons advanced for delimitation do not make sense. I don't even agree with the report of the parliamentary committee where they said delimitation is going to enhance service delivery. Because members of parliament do not provide service, they do not deliver services. So it was a lame excuse. But the question is, was delimitation necessary in accordance with the valuables being given by the Constitution? The answer is yes, because there is a report of the delimitation report, which informed the process of delimitation. There must be delimitation to take place. The reasoning, I don't agree with them. I also do not agree that I was one of those who are skeptical about saying when you do delimitation, it means that there will be more CDF that would be allocated. You know, like they are trying to talk about CDF allocation. Constituencies are not about allocation of CDF. Constituencies are not meant for development. They are meant as electoral boundaries. Okay? So for me, that reasoning is bad. Because if you use CDF, for instance, as an indicator, why wouldn't you distribute CDF using the equity principle? Where the bigger the constituents or the less developed the constituents, you allocate more resources than the other constituencies. We could have used those principles. So I do not agree with some of the reasons that have been advanced for delimitation. But I agree that delimitation was a necessary process because the Constitution dictates so. But also, I think that the catalyst which the President uses to say, we as a UPND administration, we want to deliver development through Constituency Development Fund. It is in his own wisdom and policy of this administration. The previous government of Patriotic Front, the administration of the PF, they said we as the PF, we needed to deliver development through delimitation of the districts. We saw the increase of districts from 86 to 117 because they wanted more districts to be developed. UPND, the argument is that we have put more money in constituencies so that we develop constituencies. So they can use that as a principle.
Were the people being less heard with the 156 MPs?
I don't know, because there are even members of parliament who do not even speak in parliament. We rarely hear them speak in parliament. So the question of being heard...
I mean, for us to increase them to 70.
Yeah.
I want to quickly come to mixed member proportional representation, but let's touch another important issue, again on the basis of cost. What was your recommendation in regards the issue of nominated members of parliament? Because we've now increased from 8 to 11.
Yes.
Others argue that this is more of a cost, and others also want to tie it to this issue that I think in Zambia's constitution reform process, it's always been there that we need to have ministers outside of parliament, and the presidency must use that nomination power to bring these into the House.
So there are two answers. If you ask me as a member of the Zambian Civil Liberties Union to give our position,
please,
I would give it to you. If you ask me as a technical committee, I would give you the technical committee.
Please give me both.
So ZCLU position has been that ministers must be appointed outside parliament. ZCO position has been that we no longer need nominated members of parliament in view of the fact that we have introduced a mixed member proportional representation system. The basis of that appointment nomination by the president was given by the constitution itself to say you need to consider women, youth, and persons with disabilities, other skills, people that have other skills. If we have achieved that through the 40 new seats that have been created, what would have been the use for the nominated members? From the technical committee point of view, our recommendation was to increase it to 10. You will see in our draft bill, we said the number should increase to 10.
What was the rationale?
And the rationale is that the president must be allowed to appoint professionals, to nominate professionals to the National Assembly. That was the overriding position. You have professionals like you, Costa, who would add value to the deliberation in the National Assembly. And yet you are not a politician. You do not want to join politics. The president should be allowed to use that that provision to nominate persons like you, who are professionals, to go and debate in the National Assembly. So it was about enriching the quality of debate in the National Assembly when you appoint professionals. So that is the reason why we retained it, but we had to keep the number to as low as 10.
Allow me to get your position as ZCL, which others seem to lean on more now, the logic behind the fact that why have nominated members of parliament when we have introduced 40 new seats. I'll go straight to the new act, which says in Article 47 of the Constitution is amended by the A, deletion of clause 2 and 3 and the substitution therefore of the following. Elections to the National Assembly shall be conducted under a mixed member proportional representation electoral system as follows. A, first past the post electoral system for members of parliament contesting for constituency-based seats. I want you to explain to the people what that means. B, proportional representation electoral system for women, youth and persons with disabilities as prescribed. And 3, elections to council shall be conducted under a mixed member proportional representation electoral system as follows. A, first past the post electoral system for mayor and council chairpersons. B, first past the post electoral system for candidates contesting for ward-based seats. And C, proportional representation electoral system for a specified number of women, youth and persons with disabilities as prescribed. Insertion of the following new clause immediately after clause 3. The seats under the proportional representation electoral system referred to in clause 2B and 3C shall be distributed as prescribed after a general election by the Electoral Commission to political parties in proportion to the total number of valid votes received by a presidential candidate. And C, renumbering of clause 4 and 5. Quite a mouthful there.
Yes.
Let's break down what this mixed member proportional representation system is, because this is in comparison to other countries. South Africa, for example, it is on the basis of sometimes parliamentary seats that you allocate a percentage. What was the submission of the technical committee? We are told after you presented the report, government has departed, especially in this Article 50, in this clause 4, where they're saying instead of it being attached to a percentage of parliamentary seats, it should now be a representation of proportional total number of valid votes received by a presidential candidate. But let's straddle through this article from A, B at parliamentary level to explain what first the past the post means and everything in this article.
Yeah, so the starting point, Costa, is not that article. The starting point should be Article 45 of the Constitution. Article 45, clause number 1, paragraph B and C tells you that the electoral system provided in Article 47, which is that article that you have read, for electing the president, member of parliament or councillor shall ensure, C says, fair representation of various interest groups in society. D says gender equity in the National Assembly and Council. So, any electoral system that we design as a country needed to conform to this principle. And we said, is the current system the first past the post system where we go turn up and vote directly for our members of parliament? Is it promoting fair representation of interest groups, especially the marginalized youths and persons with disabilities? Our answer has been no. Does it promote gender equity in the National Assembly? Our answer has been no. We have been seeing women representation going down each and every now and then. If it's in the councils, there are various councils, Costa, where we have gone in these provinces and districts, where there is no woman. There is literally no youth in those councils. Yet the Constitution says that there must be fair representation. The electoral system must promote that. So what we have now is an electoral system that promotes gender inclusive, that promotes inclusivity, various interest groups, and gender equity. What it means is that we'll continue with the system of electing members of parliament, the way we have been electing members of parliament, using the constituencies that are allocated. Now these constituencies will be 226 with the creation of those 70.
Using who gets more votes?
Who gets more votes
gets to win.
Gets to win.
For the 226.
For the 226. Then we have introduced the proportional representation system, which will allow political parties to give the list. They will supply the list. For instance, we have said 20 women in the National Assembly. That article you read earlier, we said there will be 20 women. So a political party is going to have a list of 20 women. These will be chosen through an election conducted within the political party. And it is mandatory that a political party must conduct these elections. Because Article 60 of the Constitution says that a political party must use the elections.
Let's just get it very clear, Isaac, here. These 40 seats, will they have specific constituencies or they will just be representatives of these particular minority groups?
So they will not have constituencies.
Will I, as a person, go to vote for these people?
No, you will not vote for these people. So your vote for the president is an endorsement of the party list of that particular political party. So when you vote for the president... So let's
break it down in practicality for people to understand.
So here is a breakdown. Let's use 2021. If we had this provision of the mixed member, it means that each political party, apart from the 156 seats, would have also had 20 women on a list given to ECZ, 15 youths given to ECZ, and 5 persons with disabilities.
Each political party contesting with a presidential candidate.
Yes, with a presidential candidate. Then, after the election, like it happened in 2021, the UPND presidential candidate, Mr. Hakainde Hichilema, had 59%. Okay? This 59%, how do you allocate these seats? So these seats means that the number of votes that Mr. Hichilema has gotten, let's say the 59%, you use that as a proportion to determine how many seats they will get from this.
Meaning the UPND will get 59% of seats out of the 40.
Out of the 40.
Yeah. So here then comes where people...
So PF would have... Let's take an example of women. From the 59% that Mr. Hichilema had, they would have had 12 seats. The PF had 39%. They would have 8 seats, if you calculate, for women. That will give the number to 20 seats. The other political parties...
Which means the seats
zero.
Are done.
Yes.
Now here's where many people are seeing the dispatch, especially in Article 47, Sub-Article 4. That in many jurisdictions, this is usually taken as a percentage of the parliamentary seats that each party gets. And as you see, at National Assembly, we're using the first past the post. At local government level for mayor, we're using the first past the post. Our electoral system at presidential level in 2016 changed after we amended Act number 2 of 2016 to a majoritarian presidential system to 50% plus one. So automatically, the question is, how fair or representative is it in a majoritarian presidential race that we subject the proportional representation to the presidency and not the first past the post?
If it was up to me, my views are reflected in the report that we did, that we should have used the parliamentary election to determine these seats. And if it was up to me and the Zambian Civil Liberties Union, we would have used the parliamentary seats. Now that this is law, probably it would be water under the bridge. Okay, because to change that again, you need to go through that process.
Is there anywhere in the world that this type of a system works in this manner? Because proportional representation in most jurisdictions works as a percentage of parliamentary seats.
Yes. It actually works in proportion to parliamentary seats. I agree with that. And that is why I've said, if it was up to me and the Zambian Civil Liberties Union, we would have gone for the parliamentary seats. If it was up to me and the technical committee, would have gone for the parliamentary seats because that is what we had recommended. But members of parliament themselves said, no, don't use our parliamentary elections, use the presidential.
What logic did you think we were using to arrive at that?
The logic for me is this. If you looked at 2021, for instance, the number of people that voted for the presidential candidate, PF presidential candidate, compared to those that voted for the parliamentary candidates, you find that probably the PF had more numbers at parliamentary level than at the presidential level. The same can be said about the UPND. They might have had more. If you look at just their numbers in parliament and the votes that these people are getting, you will discover that in Eastern Province, you had the members of parliament for the UPND winning, but the presidential candidate losing.
That could be rational. But from a governance perspective, there are some who are arguing, Isaac, now that this gives the presidency so much power to, quote-unquote, run a de facto one-party state. And for the longest, part of these constitutional reforms have been, let's reduce the power of an individual called a president, because based on the 50% plus one majoritarian requirement, out of the 40 seats, it automatically means that on the minimum that I get 50%, that's the requirement. I already get 20 seats.
21.
21 seats out of the 40, regardless of how we break them. Plus now I've got the power to nominate 11. So somebody has already bagged almost 32 seats that they can control in their favor.
What we must look at as well is what is that proportion of the 42 to the number that is there in the total number, which is 280 members of parliament. Then it was 156. The president was still allowed to nominate 8. So the 8 issue, in terms of the increase...
The 11 is 5%.
So in terms of that, I think that there is no much of the... no much qualms to say there's an increase of three more seats, whilst we have increased parliament by almost half. You see that, eh? We have only added 3 more seats. The issue is about the 50% plus 1, which you have talked about, which will give the winner 21 seats. And that Costa must call for the opposition and the ruling party to sit down and strategize on how to win an election.
And these are the intricacies that we should have been looking at.
And it shouldn't be looked at it from the point of the UPND administration, the man who seated as Mr. Hakainde Hichilema. No. Because if the opposition wins by 50% plus 1, it means that they start with the 21 seats. Okay? So in a democracy, this is a democracy we are talking about. The opposition must put their house in order agree if they want to have a list of 15 candidates on the ballot to ensure that they can get those seats and lose an election.
Because this is now law.
This is now law. So they must see it. It's a wake-up call to everybody, either the opposition, especially the opposition, but also the ruling party. They must understand, once they lose this election, they get 49%. Another one gets 51%. It means that the opposition will get the 21 seats. So it works either way. It doesn't favor just the UPND.
Furthermore, there was always talk, even under Bill 10, on the problematic aspects of the Act number 12, 2016, nomination, resignations, and by-elections. And in particular, Article 52.6, the Act changes the rules on fresh nominations where a candidate resigns or is disqualified. Has the mischief been cured?
Well, the mischief has partly been cured, in my view. Partly been cured. Why do I say it has been partly been cured? Is that whenever a candidate resigned or sponsored by a political party resigns or was disqualified by a court, the election was cancelled. And it was problematic to always cancel an election at the 11th hour. People have already invested money, political parties have invested money, you cancel a by-election. That was not justified. So partly we have cured that, but partly we have not cured something that is more, we might be creating a monster somewhere. Because this is what will happen, Costa. When you resign, you are sponsored by a political party. Mudiokela's party sponsors you as a candidate. Then 2 days later, you resign, or somebody buys you off and says, no, my friend, step aside, here is the money, go. It means that your party has been denied an opportunity to participate in that election. So imagine if 20 seats were bought by candidacy, the opposition buys 20 candidates from the ruling party, or the ruling party buys 20 candidates after filing the nomination from the other places. It means that that political party, even if they wanted, even if they knew that we were going to win, they have no opportunity.
In the new amendment, it's proposing that the political party that suffers that loss can then replace a candidate.
No.
And the election,
it doesn't.
And the election should be held in 30 days?
It doesn't. It doesn't. So when you resign...
A person who intends to be a candidate for election as president, member of parliament, for a constituency-based seat, mayor, council chairperson or councillor, for a ward-based seat, shall file that person's nomination paper to returning officers...
I think you may need to read the 52.6.
52.6, yeah.
Yes.
Yeah, where a candidate resigns after having been nominated in accordance with this article, the candidate shall not be eligible to contest the election, and the election shall proceed to be held on the date prescribed for the holding of the election.
That's what it says.
B, has been disqualified. In C, sponsored by a political party, dies before the date prescribed for the holding of an election. The Electoral Commission shall cancel the election and call for the filing of a fresh nomination by the political party whose candidate died, and the election shall be held within the days of filing of the fresh nomination.
So just to appreciate that, and what you need to tell the people, Costa, is
when a person dies.
When a person dies.
Not resigns.
Or
is disqualified.
Not disqualified. So when you resign, you have been induced to resign by your rival candidates over a rival political party. It means that the election just goes ahead. It doesn't say anything.
So the political party then will have loses out.
It loses out.
Regardless of the misconduct of a selfish or greedy candidate.
Regardless of that, it loses out. And the election just proceeds. That is where the challenge is. The Zambian Civil Liberties Union and Consortium of Civil Society made submissions to the technical committee, to government, to say, when a candidate resigns, for instance, 60 days before an election, because we know an election takes place within 90 days after parliament is dissolved. So 60 days, a candidate resigns. The political party must be able to replace a candidate. That was the rationale that was given by the technical committee in 2012. The Silungwe Technical Committee, to say you must be able to replace a candidate yourself. Even those who are standing on a mixed member proportional representation. For instance, you are on the party list, and then you decide to defect to go to another political party, and you are number 2 on the party list. ECZ, when they will be allocating, they will allocate those who are number 1 up to number, if it's number 10, they will go up to number 10. The rationale which was given by the technical committee before us was that the political party was going to replace those candidates.
And this was obviously an alternate to independent candidates.
Exactly. So the idea in a democracy is that you must allow free and fair elections as demanded by Article 45. When you knock out a political party because they have been induced to resign, a candidate has been induced to resign, or they have been disqualified by a tribunal, a court, erroneously. There's no appeal, by the way, when you are disqualified by a tribunal. Imagine a local government tribunal disqualifies you on a technicality.
So your position on this as ZCO is that it has partially been cured. You still see problems. It has
partially been cured. There are problems that might come. We might see these problems emerge when political parties begin to buy their candidates or intimidate the candidates to resign because of our system of elections adversarial.
For the sake of time, let's look at this other amendment on harmonization of terms for parliamentary and council terms to 5 years, which has been presented as an efficiency measure. This amended article is saying that Parliament will be dissolved 90 days before the election, which is in May, but MPs and ministers will somehow be required to stay in office, and especially the issue of vacating ministerial offices has judicial case precedence in the case of the PF, where ministers were ordered to pay back. Why do we seem to be causing, in my view, creating problems where there were none? What are we trying to cure? What is the rationale of harmonizing the term of members of parliament? Parliament will be dissolved, but MPs will still be recognized to finish their tenure in August. How will this work, and what are we trying to cure vis-a-vis ministers and provincial ministers to vacate office 90 days before a general election, especially that there's already a Concord judgment on this matter?
So when you read in that Constitution, Costa, on Article 116, the amendment to Article 116, it is very clear. Article 116 and Article 117, ministers are going to vacate office when Parliament is dissolved. There is no staying in office. And that was a recommendation by the technical committee as well, to say they must vacate office. So that amendment was made. They vacate office, members of Parliament vacate office 90 days when Parliament is dissolved. But the argument from the government side, the people that sponsored the bill, which they had the right to sponsor, they said, no, the Parliament must dissolve a day before an election, which we disagreed, which the Zambian people disagreed, to say it's not going to be fair to other candidates, and it will create abuse of resources. Okay? And this is the way politicians are, Costa. It is not just the UPND that made this proposal. When you read Bill 10 under the PF, Article 116, Article 117, they were very clear. Ministers shall stay in office and hand over after another minister takes over office. Not 2016, but in 2020. That was their proposal, because they wanted to stay on in office. But the Zambian people said, no, you can't do that. So we are happy that government has listened to the people. Parliament remains dissolved 90 days before an election.
What about this harmonization?
No member of Parliament remains. Now, the harmonization we are talking about is under Article 81, which says members of Parliament shall they'll be deemed to have served 5 years.
So in short,
it's a deeming.
It's about paying them
for the 3 months that they stayed in office, because we know, to say, probably that has been the issue for some members of Parliament. But also the Constitution talks about 5 years, that a member of Parliament shall serve for a period of 5 years. Now, to complete the 5 years, the argument was that the 3 months...
They were not being paid.
They are not being paid, and their term is literally 4 years and 9 months. Especially when you have to remove the time when they are sworn in, 1 month is lost. Could have that been the motivation of the unanimous vote we saw? That was a motivation. So for me, I would tell you to say, I'm happy that Zambians came out in numbers, and you, the media, you did a very good part to do the campaign to show that you cannot have ministers stay in office until a day before an election, or an MP to stay in office a day before an election. Even we at ZCU, we disagree with that principle. And we agreed with the people that there must be 90 days dissolution, and it has remained so that 90 days Parliament will dissolve. The ministers, the members of Parliament who deemed to have served 5 years, means that they will get their gratuity, they will get the emoluments that are entitled to them, but they will never remain in office physically, as it was intended.
Isaac Mwanza, thank you so much for coming to talk to us on Costa's cross-examination.
Thank you very much. I hope I've done well with this cross-examination.
Well, there are still more articles that we need to dissect, and obviously other Zambians will be able to give their opinions and views. And I think it's in 6 months before an election, most of the citizenry need to be enlightened on what will happen, how MMP will work, how first past the post will work. I think it's important.
Indeed, because it's important. But my appeal again is to the opposition political parties. Let us forget about the spilled milk, about the Bill 7 and Bill whatever you want to talk about it. Now we have these provisions. You know that the 40 seats will be allocated on the basis of presidential vote. Do you want to have a list of 15, 20 candidates on the presidential vote, such that none of you might get a single seat from those votes? That should be the question to them. Because you will not win an election when you have a bigger list. So it is up to them now to sit down. Also the mixed member proportional representation. Can they sit down with government to talk about it, how it will work, so that there is an agreement? Can they also sit down to talk about delimitation, where it's supposed to take place? Because if you continue crying, the train is moving. And you'll find ECZ will just publish the list without your input. So it is time to make an input rather than continue to cry over Bill 7.
Thank you. Well, those are the issues 6 months before an election. Zambia definitely does go to the polls in August of 2026 on the 13th. And Bill 7 is now Act number 13 of 2025. So whether we like it or not, 70 new more constituencies will need to have elected members of parliament and 40 more new seats under the mixed member proportional representation. More education and sensitization in what needs to happen and how this delimitation will go on is expected of the Electoral Commission of Zambia and other authorities. Thank you so much. Costa Cross-Examination is now adjourned.